We've got two great speakers who are going to kick it off. Bill and Kelly are from University of Wisconsin Extension, are going to talk on some of the legal things and talk very specifically about contracts and some of the aspects of contracts, and then also some things to keep in mind as you move forward and things to think about. I think the key point that you'll hear from both of them is, and Sherrie for that matter, is that none of us are encouraging you to say yes and think solar or renewable energy contracts are the best. And none of us are going to tell you that renewable energy contracts are the worst. What we want to do is provide you with some great information so that you, as an individual, can make the best choice for you, your farm, your family, and those involved in your operation and your investment. So that's what Bill and Kelly are going to do. Sherrie is going to talk to us and really set the stage a little bit for us on a broader scale and talk a little bit about some grant dollars. And you can see on your screen right now, you can see on the right-hand side on the bottom there, it talks a little bit about the U.S. Department of Energy awardee. Sherrie's going to talk a little bit about that, and then going to talk a little bit about solar more nationwide, and then drill down a little bit to Wisconsin as well. So there will be time for questions. If you have questions, by all means, put those into the chat. I'll be monitoring that and can get those questions asked of Bill and Kelly and Sherrie as well.
We will have Sherrie kick off, which is actually great because she really sort of sets the stage for what solar looks like today. So Sherrie, I will hand it over to you. You may have control of the slides, but if you aren't able to advance them, let me know and I will click through them for you.
Okay, great. Thank you so much. And good morning, everyone. First, I want to say that the views expressed today don't necessarily represent the views of the U.S. Department of Energy. That's because we have funding from a grant that we're very excited about. And I'll tell you about that work a little bit later in my talk, but just wanted to make that disclaimer. So let's start out by talking about this really exciting time that we're in. We are living through the biggest shift since the Industrial Revolution, that second technological revolution that brought us electricity, steel, and oil, and improved manufacturing, expanded transportation, and improved health. And this is happening again, except this time, instead of with fossil fuel, we're moving to a clean energy economy. So solar cells, according to The Economist, will be the largest source of electrical power on Earth by the mid-2030s. So just to give you a background to ground you on like what's happening in Wisconsin, because this transformation is fast, it's really rapid. And so we're all kind of trying to catch up. And so what's happening actually around the world right now is that renewable energy growth is doubling every 2 years. And just in 2023, more than $1 trillion was spent worldwide in investments to get us to renewable energy, electrification, and get the infrastructure in place that we need. In the United States, this year, solar and wind energy and battery storage are expected to make up 94% of all our nation's new energy generation. The reason being is because solar and wind are now very much less expensive than energy, electricity coming from fossil fuels. So they can outcompete, and that's a big part of that is because it has much less maintenance, and also because it doesn't have the environmental impacts, as well as the fact that once the projects are built, the fuel sources don't have a cost to them because they come from the sun and the wind. So part of this trend is that coal plants have been closing. There are more than 500 coal plants in the country, and since 2010, at least a third of those have closed. We've seen 11 coal plants close in Wisconsin too. That picture on the bottom right is the power station in La Crosse that just this summer, or I guess spring now, was demolished. So we're also seeing an increase in battery energy storage and other energy storage technologies. And that's important because, you know, the sun doesn't shine all the time, and it certainly doesn't shine at night. And the wind doesn't always blow, but when you can store the energy with battery storage, it's very powerful in terms of allowing this energy to be used at, much more often. And so that's been helping a lot, and the cost for battery energy storage are going down. The cost for solar went down within 10 years more than 90%. So it's becoming so much more affordable. And if you look at the trends, right in 2022, there were more than 10 million US homes within 3 miles of large-scale solar. And these graphs just show you the trends in the different fuel categories, with solar going up, starting from 2010 to 2020, where that dashed line goes, to 2022. And then wind is going up, whereas natural gas went up, but it's leveling. Nuclear is going slightly down, but level. And you can see coal is the greatest decrease of fuel that we have. What's causing this rapid transformation? Well, policy is one of them. The cost is really the biggest one. It's economical. And that's what drives businesses, is the bottom line. But we have a federal policy to get to clean electricity by 2035. We have a policy in the state of Wisconsin to get to 100% electricity consumed in Wisconsin to be carbon neutral by 2050. And also our utilities have adopted their own goals, and they vary, but the major utilities, you know, have 80% by 2040 or 100% by 2035. A study was done, well, how do we get to that clean energy grid in Wisconsin for electricity? And the Center on Wisconsin Strategies did a study and said that large-scale solar could supply a little under 32% of our energy, and to get us there, which would be about 240,000 to 285,000 acres in the state. So if we look at that in terms of harvested cropland that's planted in soybeans and corn, that's about 2.6 to 3% of Wisconsin's harvested croplands. Well, one thing to realize is that Wisconsin is already using a large portion of our land to grow an energy crop, and that's corn for ethanol. And of the 4 million acres we have planted in corn, 1 million is planted for ethanol use, of which we're sending twice as much that we consume in the state out of the state. So it's interesting just to keep that in mind, because the amount of land that would be needed for large-scale solar to produce our clean electricity grid is a third of that. Also, in Wisconsin, at the Center for Land Use Education, which is at UW-Stevens Point, they produced a map where they analyzed what are the most suitable lands for solar across our state. And you can go to the map and zero in a little bit more into your area, but you can see that it's not all of Wisconsin. So the upper northern part, where there are a lot of trees, is not really good, but we have a lot of open farmland more in the central and southern parts of the state that are good for renewables. So we're talking about maybe 50 of our 72 counties. If you look at the data from the end of 2023 from the Solar Energy Industries Association, they always do a lot of analysis. We see that Wisconsin then was ranked 18th in our solar output, and that created over 3,200 jobs in our state. We've got 101 solar companies, and so far, but it's actually been increased. We've had $2.6 billion in investment just in large scale solar, and well, actually in all solar investment in Wisconsin. Excuse me for that. And so all types of solar, whether it's rooftop or over parking lot, parking canopies, or on businesses, et cetera, and large scale and community scale solar, all of them total to over, 15,708 installations. And as you can see from the graph, since 2020, the blue is utility scale solar. And you can see that just from 2020 to 2023, the huge increase in the amount of large scale solar that's happening. And that's why people in our farmlands are finding that they're being approached by developers to contract for use of their land for these large scale solar installations. Just to look at it in Wisconsin, in 21 of our 72 counties, we've got large scale solar, 33 developments either approved or actually built, 13 of which have battery energy storage. That will increase. So just in 2023, the Public Service Commission approved 1.3 gigawatts of solar, which is 2 times more than what was approved in 2022. And along with that is not just that they're built, but that the communities actually get money per megawatt of solar that gets built on their land, And so it's divided 60% to the counties and 40% to each of the host municipalities, whether it's villages and towns or multiple towns. And so it's $4,000 a megawatt. And then based on the amount of the solar in each of the areas, you just do the math, and that's what the communities get. So just looking at the 1.3 gigawatts that was approved in 23, that would generate $1.5 million annually in payments to local governments. And we are encouraging that. So we're letting people know that there is this financial upside to their community. It's not just to the farmers. And we're really promoting the idea that local governments, once the money comes, which is once the development is actually finished and the solar is being generated, that the community gets involved in deciding how to use these funds to really move their communities into ways that they would like to go into really good investments. And again, these are annual payments for 25 to 30 years. I just want to give you a background now on what Extension is doing in this realm in our state. And the reason being that we are helping you with what to look at for your contracts in this workshop, but we're also doing other work. And we have been working in the last year in Portage County, using that as a pilot, actually part of a national pilot, to look at how do we engage communities so that the development of solar facilities contributes to advance their long-term priorities and the prosperity of their community. And so to do that, we've been doing a lot of research to find out how do people feel about this, who are different stakeholders in the areas where they're happening. And so we looked at the perspectives of the stakeholders by doing focus groups, and you can look at the list on the slide: public officials, farmers who have contracts, landowners who are near but not getting contracts, the youth, environmental and local leaders, and the farm businesses and the supply chain. We also interviewed people who've worked in counties where there are already, and local jurisdictions where there are already solar facilities, to find out what their experiences were to inform what we are doing. So aside from doing that research, we also held community conversations in Portage County. We did two in two different parts, but they were the same. And it was basically listening to people because they often feel left out. A lot of times the developers arrive long before the community knows that this is going on. And so we were running these to improve solar development processes and outcomes for all folks and finding out what were people's concerns, what did they think were the benefits, how would they like to get involved, a number of things. And it worked out really well, and we'll be reporting on that and developing resources for you based partly on that and partly on the fact that we just got another grant to work on, again, on renewable energy siting, but through technical engagement and planning, and this is from US DOE. The goal is to improve renewable energy planning, siting, and permitting processes and outcomes for communities, local governments, and the developers so that everybody is going to do well through this clean energy transformation. So in order to do that, we put together a collaborative. And so the Wisconsin Farm Bureau, which is one of our hosts here, is on our collaborative, as well as other stakeholder groups. And you can see what they are, from the Farmers Union and Wisconsin Land and Water to, we have a tribal representative, and we have the Public Service Commission and the DNR are part of this. So they are also looking to improve the systems and the processes that we have out there that right now can be pretty contentious. We're also including UW-Madison's Office of Sustainability and a couple of different types of renewable energy developers, because this is about both solar and wind and energy storage. The objectives of the program that we're doing, and it's a 3-year program, and this is part of it, is to expand the decision-making capacity and expertise of our local, state, and tribal governments around large-scale renewable energy planning and siting, to educate and engage the local stakeholders in communities so that the decisions that are made are respectful of community values and a lot of other considerations, including involving everyone in the community so that it's not just one group that benefits, but it raises all boats. And then to use this collaborative to inform our decisions and actually to make substantial change that will work for everyone and improve our processes. Just to say that in Wisconsin, large scale solar energy and renewable energy, so wind as well, is defined as 100 megawatts or greater. So, we're talking about 250,000 acres, or 2,500, acres of land, and typically, and although it varies. But the federal definition of large-scale renewables is 1 megawatt and up. So we will also be working on other kinds of renewable energy systems in our state. And here you see one at Vernon Electric Co-op, where they're doing about a 5 megawatt community solar project where local folks can actually buy in to that energy and then see a stable rate for their electricity costs over time. We'll take questions when we could do it now, or if you want to wait till the end and type them into the chat or into the Q&A. I run a program called Energy on Wisconsin. You can go to the website, the link is listed there, and that will show you all sorts of resources, everything from the state law to information about the technologies, to case studies, and also to funding that's available for all sorts of other improvements you can make on your home and your businesses and your organizations, for moving to electric generation and saving energy. So thank you.
Well, thank you, Sherrie. Really appreciate your comments this morning. So, okay, with that, there have been a couple of questions, but I think we'll save those and we'll just transition Kelly right into you and Bill. So you two can take it from here.
Fantastic. Thank you, Brad. So Sherrie really set the stage for us in understanding that federal and state policy are encouraging this transition to renewable energy. And we're seeing that transition occur very, very quickly. You know, solar is out there being developed and becoming operational as we speak. However, there aren't a lot of rules or regulations around what exactly those relationships with landowners are going to look like. Instead, that's why it's really important that we put a lot of time into thinking about the landowner contracts that are being presented to us. So Bill and I are going to do we'll say 30,000 foot overview of what are those items that you should be thinking about if you're presented with a solar lease. In true legal fashion, we're going to start off with a few legal disclaimers. That the information that Bill and I provide today, although we are both licensed Wisconsin attorneys, we're not your attorneys. So the information is for educational purposes only. It's not legal advice. And if you have an agreement, you probably want to talk to your own attorney about if there's anything that you should be negotiating. That being said, we'd also like to take a second to thank our partners. Both Wisconsin Farm Bureau and Ag Country Farm Credit helped us out with a few in-person seminars last week and have been supportive of the work we're doing here. And so we just want to recognize them for that help. So where do we go from here? If you look at the workshop roadmap that you see on your screen now, we are going to cover a lot of topics around solar. We're going to do our best to make it accessible, and again, put questions in the Q&A that we will circle up with at the end. But we're also going to be providing a few, I'd like to say physical resources, but since we won't be meeting with you in person, you'll be getting a link to them. But a few guides and a fact sheet that you'll be able to read through to sort of recap the items that we're talking about today. With that, Bill, do you want to kick off with what are solar developers looking for?
Yes, thank you very much. And good morning, everyone. Glad you're all with us. And just a little bit of background on Kelly and me. Very briefly, we both grew up on farms. And so we've been very close to agriculture all of our careers. In my case, it's been about 37 years practicing law and working closely with farmers. And I'm, of course, now doing it from my professor of practice law position at UW-Madison. So just to begin, what are solar developers really seeking? What they're looking for in Wisconsin are long-term land lease agreements in writing. And typically what they're paying is anywhere from about $500 to $1,500 per acre. And I should say at this initial point that Kelly will jump in from time to time because we're very much like doing this as a tag team. And it's our way of kind of keeping this conversational as well. So hopefully that doesn't throw you off. But Kelly, why don't you just talk a little bit for a moment on what you've seen in terms of the stages of those payments?
Certainly. So what we have on the slide here is talking about that $500 to $1,500 per acre per year offer that is being seen in the operational stage. So once those solar panels are up and actually producing energy. However, what we see in a lot of these lease agreements is that payments are going to be staged. So there's typically 3 stages: a development stage where the solar developer has the land under lease, but they're trying to figure out, is this the right location? They're going through the permitting process. And so the farmer may still be able to farm that land during the development stage, but the land lease rate from the solar developer is going to be a lot lower. It might be only $100 or $200 per acre, while, again, they're doing this testing and seeing if they actually are going to use that land. Once they decide to move forward and they're headed into the construction phase, that number tends to increase. So again, thinking more in that $500 to $600 range, and before finally completing construction and becoming operational. And that's where we're really seeing those high numbers, that $500 to $1,500 per acre. Now, not every lease is going to have all three stages, I should say, and not every lease is going to have the same length. But some common terms that we've seen are, again, that $100 to $200 per acre in development, usually 2 to 3 years. Construction, again, $500 to $600 per acre, usually 1 or 2 years. And then again, that operational lease term being that higher value lease rate and typically lasting closer to that 15 to 20-year mark.
Thank you, Kelly. So hopefully that's really helpful background. In our first 2 sessions, we had some landowners actually bring their proposed agreements with them and got a sense of where payments were running. And generally speaking, the numbers that we have on the screen are pretty reflective of the numbers being seen by producers in the offers, or by landowners in the offers that they're seeing across the state of Wisconsin. So secondly, the developers are really looking for land free of trees, buildings, and other obstructions to sunlight. That's pretty obvious, but I live in Southwest Wisconsin, west of New Glarus, and we're in the very hilly driftless area. And as you might remember from Sherrie Gruder's map, we're not considered a really great area for solar development because half the land's going to be on the other side of that hillside and shaded from the sun. But also, very importantly for solar developers, they want land located near roads and power transmission facilities. So the closer you are to the roads, the major public roads, and the closer you are to a substation, the higher the payment you're likely to be offered from a solar developer. And then finally, the solar developers are looking for communities where there's little or no political opposition. In some parts of the state, there's been fairly intense political opposition. Solar developers who want to get their projects up and running are most certainly looking for those places where there's a great level of acceptance and where there's less political opposition that might delay construction of the project. So some landowner considerations before contracting. Let me just put out a disclaimer of a different sort here. Kelly and I might seem to be a little bit negative. We're not really negative. It's just we have to talk about the risks that are in these solar agreements. And as we talk about risks, that may come across as being negative. As Bradley said, we're not for or against, but as lawyers, we want to make sure that you're fully informed. So if you're a rural landowner looking potentially to lease some of your farmland or other land to a solar developer, we just want you to be well informed. And I'll just note that I spent 6 years as head of the state's Consumer Protection Agency. And one of the very important tasks for my 200 staff and I had was to make sure that agreements to the greatest extent possible were fair and didn't engage in fraud. So I come from this very much from a consumer protection perspective. So having said that, as the first bullet notes, leases offered by solar developers to rural landowners are written by solar developers' attorneys. And so they know what provisions to have in there, what those provisions mean. And you as a rural landowner probably didn't or won't be given much of an opportunity to write an agreement. It's not going to be you providing agreement to the developer, it's the developer providing the agreement to you. So as a result of that, these agreements tend to favor developer more than landowner. What I mean by that is to the extent there's risk, the risk is shifted more towards the landowner. So one example of that is decommissioning. What happens at the time that the solar array has run its useful life, which may be 20 or 25 years, and we're going to decommission it or take it down and no longer use it? Who has that responsibility? We'll talk more about this later, but several of the options, or at least a couple of the options we've seen, is where the solar developer will say to the landowner, at the end of its life, 25-year contractual life, we'll give you ownership, and won't this be a great deal? Because now you'll be able to generate energy, and all of the economic value will go to you. Well, the problem is solar panels tend to degrade 2% 8% a year on average. And so at the end of 20 or 25 years, they're going to be much less effective at generating solar energy. And so that may not necessarily be a good deal for you. And so these are the types of things that we want you to think about now, because this will have importance as to what provisions go into your agreement. Agreements are often long and relatively complicated. I say that as a lawyer who's been practicing contract law for about 37 years. And so, as Kelly's already said, but I will say, and we'll probably say multiple times more, it's really important that you consult with knowledgeable legal counsel. And not necessarily your local attorney who does wills, trusts, and estates, but someone who's actually looked at solar agreements and helped advise farmers and other rural landowners on what those agreements mean, what provisions you should negotiate for to help benefit you. And before you enter into negotiations with the solar developer, you want to think about what are the short and long-term uses of your farmland. So what might seem like a really good possibility of leasing 40 acres right now for a solar array might not seem like such a good deal or such a good arrangement for the next generation who plans to farm your farm. And they may have different ideas of what should be done with that land. And so it's really important that you not only think about what's now, so now being the next 0 to 5 years, but what comes after now, which might be 5 years out into the future. And then what impact will the lease have on farming operations? We'll talk more about this in a bit, but I've received calls, I know Kelly's received calls of farmers saying, I entered into this lease and it was for a certain acreage, 20 or 40 acres, and the developer put a fence around that to help protect. And one of the farm roads I typically use for my farming operations now inside that fence. What do I do? So that's an example of a thing to think about in advance, is if you need access through that land that you're about to lease, you need to reserve the ability to use or to retain that access in the agreement. And then also you might have land that is less valuable. So it's a lower class of land that could be leased without impacting your farming operations, but it'll still generate the same payments from the solar developer. You may very well want to think about that. So the solar developer is always going to look for the land closest to the public roads and to that substation, but you may have 40 acres next door, essentially, a little bit further from that public road, but they're still going to offer you the same amount of money, but it's a lower quality of land. You might want to consider then offering that as the land that's leased. And then part of the reason we're doing this whole presentation is to learn about key agreement provisions prior to negotiating. Kelly and I've already talked about this guide. In this guide talks about the key agreements that are key provisions that typically are in these agreements, what the provisions mean, and in many cases, how you can best negotiate a provision that benefits you. And so this is something that we highly recommend you look at before you engage in any negotiation with the solar developer. And then finally, go into the negotiation process with your eyes open. You know, we've gotten into a world where we're so used to getting software over our iPhone or other electronic device where it just says consent. We hit the consent, we never read the agreement. And there's a case right now, for example, that deals with Walt Disney. And Walt Disney has a streaming service, and a consumer consented to do a 1-month trial of that streaming service back in 2019. They just clicked and did the month trial. Then they decided they weren't going to continue with the service. Well, later on, they visited a Disney theme park. The spouse was badly injured, actually died from an allergy. And Disney is claiming that, or at least had been claiming that original agreement that consumer signed, which really had nothing to do with visiting a theme park, then meant that any disagreement had to go through arbitration. And so most of us are not reading all these agreements that we're getting with. We're just hitting consent because we want access, but realize companies are using those agreements to argue that provisions apply to us, and they apply to us in a way that's not necessarily to our benefit. Now, I will just note that last week, Disney decided to withdraw that legal argument. I think most of us who are contract lawyers thought that was very wise of Disney, that in the end, they probably weren't going to prevail in court. But this just shows you that when you're consenting these agreements, you need to know the provisions in them. So property taxes, let's talk about property tax considerations. So who pays the property taxes? In Wisconsin, there's really a double system. So for 100 megawatts or larger, by state law, the solar developer is going to pay a payment that is not technically property taxes, but that will be a payment to the state of Wisconsin, and then there'll be some revenue sharing back to the local unit of government. So that 100 megawatt dividing line is the dividing line. And just so you have a sense of this, it takes about 5 to 7 acres to generate, from a solar perspective, 1 megawatt of energy. So we're talking about multiple acres here. And by the way, a megawatt of energy will power anywhere from about 130 to 170 homes, just so you have that background. But the payment that the utility is making is based on gross operating revenues from the prior year, and doesn't have anything to do with the value of the underlying land. However, if the large solar, so more than 100 megawatts, is being operated by someone other than a utility, then the property tax system comes into play, and that large solar developer will be paying property taxes. But that's pretty rare. Most of these large megawatt solar arrays that are being created, constructed in the state of Wisconsin, are by the utilities. So under 100 megawatts, then it's property tax. And so the valuation of that land is going to be the key consideration for determining what your property tax payment looks like. And for many rural landowners and farmers, you get the benefit of use value taxation. And use value taxation is based off the productive value of that farmland. And one of the issues you need to be aware of is if you convert that farmland to a solar array, it may or may not be eligible for use value taxation going forward. We don't yet have a clear reading on that from the Department of Revenue. It's not really their decision, but the Department of Revenue guides local assessors, and local assessors' practices have been varying across the state. There is one way you can assure yourself that you will remain, or your land will remain, in use value taxation, though, is to look at another or eligible agricultural use. And for example, sheep and goat grazing, and that provides some agricultural income stream, but it also helps keep all the underbrush down beneath the solar array. And there's a lot of research going into this, and research into other types of agricultural practice that may allow the rural landowner to retain use value. So, but this is something you will want to discuss with your local assessor at the time you're thinking about contracting. Say, if I put on a 20-acre solar array, am I going to lose use value taxation benefits for that land?
I'm actually going to jump in for a minute.
Yeah, go ahead, Kelly, please.
Thanks, Bill. And just say, this is another one of those issues that, certainly you want to discuss it with your local assessor and with the solar development company. But as Bill and I will repeatedly say today, make sure that it ends up in your contract. Your landowner, of course, is always going to be responsible for property taxes, but you want to make sure, or at least consider, whether the solar developer should be paying any increase or any conversion fee that's due from losing use value assessment. And if that is the case, make sure that it is written in your contract so that it's enforceable.
Yeah, because Kelly and I will say this over and over again, but we'll put a big exclamation point on it right now, that if you negotiate some provisions of this agreement orally, but they don't make it into the written contract, it's like those oral discussions never happened. Because under Wisconsin contract law, there's usually a provision in the contract that says this is the whole and complete agreement between the parties, and any oral representations are not included, essentially. And so what that means is you need to have any promises made by the solar developer put in writing and put in the agreement, whether it's in the language of the agreement or as an attached appendix. But either way, you want to make sure that these are included. But again, if they're not put in writing, it's like they never happened. So lease location considerations, I've already talked about that a little bit. And so I've talked about what's the best farmland. Most likely, if you can avoid it, you don't want to put the solar array on your best farmland. And part of that consideration is, what am I going to need in the future? So again, you want to think about that future now. How will construction impact farming operations? That's the third sub-bullet down. because as Kelly said, there's going to be stages. So there's going to be the initial exploration where they're essentially giving you an option so that if they want to use your land for a solar array, they're going to pay you $100 or $200 per year per acre for that, so that they have access. But if they decide that they want to begin construction, you want to know what's the typical time for that construction. So if you've signed me up as a rural landowner, when typically have you started construction? Is it 2 years from now? Is it a year from now? When's that likely to happen? And a key component of that is you don't want to put a crop out in the field if there's a chance that the construction is going to happen while your crop's out in that field and you haven't had a chance to harvest that crop. And so you'll want to have language in your agreement that if I put a crop out in the field, you're going to give me 30, 60, 90 days notice, more towards the latter, 90 days notice that you're going to begin construction so that I can get my crop harvested and not lose the economic value of the seed, the fertilizer, the pesticide that you put on that land. You also want to know what local Kelly, were you going to say something?
I was going to jump in. Yep. So another thing
Go
that
ahead,
we
please.
want to think about for our farmers is going to be not only making sure that there's enough notice to hopefully harvest that crop, but just simply how are crop damages calculated and when are they going to be paid? So for example, if we're thinking about that development stage, even in those early years when they're just figuring out if that land is going to be used or not, they're probably going to be coming in and doing some testing, which potentially will cause crop damage. And so in your agreement, you'll want to think about how am I going to be compensated for any of that crop damage and how is it calculated? Of course, the sort of easy initial calculation is price times yield times acreage. Well, who's determining how many acres have been damaged? What price are we using? Is it my contracted price? Is it a price that's coming from the local market? And then, of course, yield. Are we just using county averages or are we actually looking at, say, crop monitor data for that field to figure out exactly what you should be compensated? You want to make sure you discuss that with the solar developer so everyone's on the same page, because when your crops have just been destroyed or damaged, it's probably not going to be the happiest time to try to negotiate. So negotiate up front, get it in the contract. And then another piece of that is making sure you're clear about when you'll be receiving those crop damage payments. Of course, typically in agriculture, if we're working with an operating line of credit, you're going to want to pay that off at the end of the year. But sometimes our solar developers are saying, we don't want to have to pay you every single year, just total it up and we'll pay you at the end. Well, certainly for a farmer, that may not be ideal. And so you'll want to explain to them why it's important that you get that payment every year to reimburse you for any crop damages that are being done. The other piece that I like to talk about here as we think about what should our farmers be considering is that if you are a landowner and you are negotiating in the right to continue to farm that land during the development stage, you want to be clear about, are you farming it yourself? And or are you retaining the right to lease that land to a farmer that someone else is farming it? Because those are, in the eyes of the law and in a contract, two different things. So if you're not farming it yourself and you're having someone else come in to do it, you want to make sure that you're clear about that in the written contract. There was another thing related to farmland I was thinking about, but maybe Bill has it.
Well, I was going to say, just in terms of what Kelly just talked about in terms of a sublease, if you are leasing land, you're a rural landowner, so you're not actively farming, but you're leasing to a farmer, you'll want to include in your discussions that farmer. Now, we know growing up on farms that a lot of these leases are not in writing, but there's still some obligations towards that farmer who is farming your property, besides just being a good neighbor. And so it's really important to involve them in the discussion because they'll want to know that they may not have access to that farmland sometime down the road. And if you are a farmer leasing land, then realize you can't contract with the solar developer, and it has to be the landowner that contracts with the solar developer. And because that's who the contract is going to bind. So just realize if you're subleasing, or leasing land, there's going to be some implications of that. Kelly, did that help you remember what you wanted to talk about?
It did. It jogged my
Excellent.
memory. So a different point, but for some of our farmer landowners, we have seen cases where farmers are leasing a portion of their land to the solar developer, but still continuing to farm. If you are choosing to lease to a solar developer, you may want to consider putting the land that will be under that lease into a limited liability entity, like a limited liability company or a corporation. And the reason for that is that if something goes wrong with that solar lease, whether it is a lawsuit from a neighbor, a disagreement with the solar developer, having a limited liability entity that holds that land will mean that only that land is going to be at risk. It's sort of going to protect your other farm assets, any personal income that you have, from the risks of entering into that solar development lease. So we can talk a little bit more about that later, because we'll probably talk a bit about how solar developers also use limited liability entities and some cautionary tips there. But certainly something to consider as you talk to your attorney if a limited liability entity would be right for you. Jumping back, though, I think to our slides, Bill, I know you had talked about access and we talked a little bit about construction.
Right.
Do you want to talk about some of those local regulations and how neighbors might be impacted?
Right. Okay. So one of the really important things you want to do before you sign on that dotted line is to talk with your local town or the county. If you're in a city or village, your incorporated limits, you'll want to talk with them and find out what restrictions there might be in terms of setbacks and other zoning restrictions, because you don't want to enter into this lease and then find out that there are restrictions by the local unit of government that may prevent or put some restraints on the ability of the solar developer to develop your property. Now, having said that, Wisconsin state law, several years ago, the Wisconsin legislature passed a law that says that local units of government, which includes county, cities, villages, and towns, may not prohibit solar or other types of renewable energy development. Renewable energy development is actually favored in the state law. And all the law says that local units of government can do is put some reasonable restrictions on the solar development, such as when trucks can enter, the time of day to do the construction and things of that nature, but cannot put in place provisions that will prohibit or put on so much cost that it'll seem to prohibit the development of that land for renewable energy. But you'll want to start with your local authorities, a zoning officer, to see, are there any restrictions within the zoning code that may impact my ability to lease my land for a solar development? That could include setbacks and a number of other things. Just finishing up, you'll also probably want to talk to your neighbors and just say, hey, I'm considering doing a solar development. And if you talk to them up front, you may get a lot of questions, but that's way better than your neighbor being surprised by the fact that you've entered into an agreement and suddenly this developer announces there's going to be this large solar development next door to them. At least in my experience, it's better to talk to your neighbors up front. And then may the leased land be used by landowners for another purpose. Again, just to hit this a second time, I've learned as I get older, redundancy is good, but you will want to ensure in the agreement that if some of that land can still be used by you, even though you've leased it, you'll want that put in the written agreement. Now, farmland preservation, a fair amount of Wisconsin farmland is under a farmland preservation agreement with the Department of Agriculture, Trade, and Consumer Protection. And the Trade and Consumer Protection was the part I used to head up at the department. But if you're entered into an agreement before you, or if you're thinking of entering into agreement, before you sign that agreement, contact, and you see the contact information on the right side of your screen, the Department of Agriculture, Trade, and Consumer Protection to see if the land is enrolled. Because if it is and you pull it out, there could very well be a penalty for that. Most likely there'll be a penalty for that. And so you'll want to know that up front, and that may be something that you want the solar developer to pay for rather than you paying for that penalty. But again, much like working with your local unit of government, talk to the state agency first before you sign the dotted line.
The other piece that you'll want to think about, so we specifically put farmland preservation in the slides, but you'll want to think about any restrictions that are on the land. So are there easements? Are there mortgages? Do you have
Right.
the right of first refusal with someone? And it actually is surprisingly easy to forget that we've signed some of these documents if they're 10 or 15 years old, but they're still enforceable. They run with that land. And so if you're looking at signing onto a solar lease, work with your attorney, work with a title company, run a title search, and make sure that you're not violating any other restrictions that might be on that property.
Thank you, Kelly. Okay, agreement term, termination, and confidentiality. The typical agreement term is 20, sometimes 25 years, but they often include renewal periods of 5 years. So the solar developer will say, unless you give me some kind of prior notice within 30 days of the expiration of our 20-year agreement, this will automatically renew for the next 5 years. You want to understand, is there a renewal period included? Automatic renewal period, and what that renewal period is, because you'll want to make sure that, and this could be 20 years from now, but you'll want to make sure that you understand that. So if you decide you don't want that to continue, that you'll be able to give that notice of termination in time for it actually to be legally terminated. These provisions typically are written in favor of the developer. There's usually not a provision in the agreement that says the landowner can terminate early for obvious reasons, because the solar developer has made the investment, put the asset, the solar array on that farmland, but you'll want to be aware of that. Who is responsible for the solar array when the lease ends? We've already touched on that a little bit, but you'll want to consider, is there actually a remaining value for you, the landowner? Who pays for decommissioning? Is insurance or a bond required by local government to make sure that it is successfully decommissioned? And should an escrow account be established for land restoration? So what all that means is you want to know, at the end of that 20 or 25 years, am I responsible for taking that solar array down if I don't like it as the landowner? And typically that gets pretty much to the end of the useful life. Or is that the solar developer's responsibility? From our perspective, you want to negotiate so that's the solar developer's responsibility. Most reputable solar developers have it as their responsibility, but you want to make sure that's actually in the written agreement. You also may want to ensure that there's an insurance or a letter of credit or a bond to cover the cost of that decommissioning. Why? Is because if that company becomes bankrupt, the local unit of government may look to you as the rural landowner to decommission and go through the cost of decommissioning. You want to make sure there's money set aside to ensure that that can be decommissioned where you're left essentially financially whole. And one way to do this also is an escrow account where money is set aside, put in an escrow account held by a title company usually or bank, and that money is available then at the end. Or if it's not actually needed to be used, it can go back to the developer. But if the developer is purchased, typically the solar developer agreement with you will say that heirs and assigns also assume the same obligations. So any company that bought that solar developer will be also required to abide by the terms of the agreement. But again, bankruptcy is a little different. A bankruptcy court judge, it's a federal judge, has a lot of discretion to decide whether or not they're going to allow leases to continue or terminate those leases. And so it's a little bit more of a, pardon the language, crapshoot. More of the risk may be placed on you in the case of a bankruptcy. And so just be aware that there is that risk out there. And one great way to help make up for that risk, again, is to have insurance, a letter of credit, or a bond so that the solar array can be taken down and not at your own personal cost. Kelly, looks like you want to jump in and say something.
Yeah, so one of the common questions that we've gotten when we talk about decommissioning is, well, in the event that I, as the landowner, get stuck doing this, what is that cost estimated at? And we don't have a great sense realistically because a lot of these solar developments are new and they haven't had to come back down. But each of the solar developers on that large scale size, as they're applying to the Public Service Commission, in their applications, they're required to provide an estimate for decommissioning. And so we've reviewed some of those applications, and the rough numbers that the solar development companies are estimating appear to be about $2 million for 500 acres. If you break that down, it gets to be about $4,000 an acre. Now, the piece that I want to be clear about is certainly if there is, say, battery storage or a substation, it's very possible that those costs are weighted more heavily on some acres than others. We don't have that clarity to know, so it's not a perfect number. But again, just to give you an idea, they're estimating about $2 million for 500 acres, which breaks down to about 4,000 an acre. The other piece I like to talk about when we talk about the idea of having an escrow account or a bond or the heirs and assigns piece is to also think about who owns the solar development company. So of course, as you're going through the process of potentially signing up with a solar developer, you want to get to know that developer. What projects have they done in the past? Can you talk to other landowners they've worked with? Do they have any completed projects, etc. But one piece that you may or may not notice when you look at your lease is that oftentimes that parent company, if they're a national company, for example, might not be the party that's actually named in your lease. It's more than likely going to be a smaller limited liability entity that is specific to the project and is local. So what that means, like we talked about earlier, putting your land into a limited liability entity can help protect your other assets. The same thing can be true for the solar development company. So if they are contracting under a smaller local project level limited liability entity, what you will probably find if you ask them what the financials of that entity are right now is that they don't have any yet because the project isn't yet developed. So there's no cash flow. You might want to think about, can you get a guarantee from the parent company, which just essentially says if the smaller entity cannot fulfill their obligations, the parent company is going to step in and do that. Again, there are some trade-offs. If you've got money in escrow, maybe you don't need the guarantee or vice versa. But again, talk to your attorney about some of those options. And then Bill, I'm going to ask you to talk a little bit as well about insurance and thinking about what kind of coverage level are folks maybe going to be interested in and what the structure of that should look like.
Yeah, so I was just looking at the note that Sherrie would put in there, and I'll just quickly say the state's moving to require developers to be responsible for decommissioning, and that I think would remove a substantial amount of the risk from the agreement with the landowner. So that would be, from a landowner's perspective, very positive type of action. And so talking about insurance, so one of the things that could happen is there could be an accident on the land. So a truck hits another truck. So you're operating your combine and one of the construction trucks hits you. There is, whether or not there's injury, there could be property damage. So you want to make sure that the developer has insurance, and this is property and casualty insurance. And you'll want to ensure that there is a level of coverage. Now, the level of coverage typically we've been seeing is $2 to $5 million. And that could be either a one-time event, so per occurrence. So every time there's an accident, there's that level of coverage, or it could be a level of coverage for all accidents. You want to know, because you want per occurrence as opposed to a cumulative cap of $2 to $5 million. And also, when the developer has insurance, you're going to want to ask them to prove that they have it, but you want to be added as one of the insured. So you want to be added on to the certificate of insurance that you're one of the parties that is insured. So if there's a disagreement, the insurance company will recognize that you're a potential beneficiary right away, instead of you having to go through the process of proving that you're a potential beneficiary. So again, you want to make sure you have insurance. You hopefully have farm insurance or insurance on your land anyways, a rural landowner, to cover any type of negligence that you might commit, any type of unsafe situation, but you want to make sure that developer has insurance as well. And then confidentiality. And this has been something that has definitely been of interest to us during all three sessions that we presented, the two in person, the one virtual, because some of the, as I mentioned earlier, some of the participants have been bringing their agreements with them and then start asking us questions. And we can't really respond to specific questions about specific provisions. But one of the things we found interesting, particularly in Marshfield, is there started to be some discussion, well, I was offered this amount per acre, and someone else said, well, I was offered this amount per acre. And we had to remind them that there's confidentiality clauses typically in these agreements, meaning you as the party that is agreeing to lease your land must keep the terms of that confidential. The only one you can talk about it with is typically the solar developer. And so realize that these provisions are in the agreement and there may be penalties that apply. Why do solar developers want this? Because they don't want parties comparing what they're being paid, because that might increase pressure then to increase those payments. And so realize those provisions are there. And even if you haven't signed the agreement, you may have signed a letter of intent, a LOI, and that may have a confidentiality provision in it. Now, we knew at the Marshfield session that no one had actually signed an agreement at that point. Not clear how many of them may have signed a letter of intent, but this is just something to take into account, that if you're going to talk about it with other people, once you've signed on that dotted line, there may be a confidentiality provision that applies to you.
But do keep in mind that that should not restrict you from talking to your attorney or accountant or lender or any of those other advisors that you do need or probably should consult with prior to signing and as the project continues.
And as we go, the next slide will actually speak to that in a moment. But payment terms and insurance, I've already talked about insurance to a large extent. There's different options for payment. And Kelly, I don't know if you want, since you've typically covered this, if you want to jump in or if you want me to just quickly hit it.
Sure, I can jump in. We'll give you a chance to give your voice a break. So when we talked earlier, we talked about how we typically were looking at that $500 to $1,500 per acre per year rental rate. So that is like a base payment on a number of leased acres, but that isn't the only way that solar developers are offering payment. It's probably most similar, for those of you who have rented farmland, it's probably most similar to that cash rent that we're pretty used to here in Wisconsin. But again, that being said, there are some developers who are offering alternatives. One alternative is to tie those lease payments to the actual power produced from the array that's put on your land. So it might be some percentage of revenue or generated income, but it may not necessarily include any base payment. If that's the offer that's given to you, again, you certainly can negotiate it to a base payment, or if you're open to accepting some of that risk, you can stick with it. But you want to ask questions about what have similar arrays produced? What do they expect to produce off of this one? What type of payment might you be expecting to see if, again, you're getting, a lease payment that's tied to the power production? Alternatively, sort of a middle ground, you might have a payment that combines the two. So perhaps you have a base rent that's lower, but you're going to get a % of that generated income. So, again, if we think about a base payment, it's going to be a lot more similar to that cash rent that we're used to. Tying it directly to power production might be more like a crop share lease if we're comparing it to agriculture, or again, somewhere in the middle, like a flex cash rent number is a third option. Bill, you look like you want to jump in.
Thank you, Kelly. And I'm a little bit hoarse because before this, I had to do a welcome to all the teachers and the staff in the Glarus School District because I'm the school board president. We're in a large gymnasium and I had to talk very loud. So my apologies if I'm coming across a little bit hoarse. So when payments start, and Kelly's already talked about this a little bit, but there's typically a due diligence stage where the solar developer is getting leases signed so that they have commitments, basically options on that land. So then in their application to the Public Service Commission, they can show we have this amount of acreage that's part of our solar development, and we have preliminary agreements on them. And so we're quite confident that our solar array is going to be of this size. And so there's a due diligence period. Oftentimes there's no payment made. Once again, though, to the extent that you can, negotiate for payment while your land is tied up with this option, because options have an economic value. Again, it's probably going to be $100 to maybe $200 per acre per year, but that's something you'll want to negotiate for. Also, if the project isn't started right away or delayed, it may delay you. You may have ideas of what income stream is going to start flowing and when it's going to start flowing. But the developer may have different ideas of when that income stream is going to start flowing. And so you'll want to ask that developer, typically once you've entered into this agreement during this due diligence, how quickly have you begun construction? And you want to get a sense from the developer of what that time period looks like, because some developers may take a fair amount of time. Other developers might enter into construction right away. And so you'll want to understand what is that time period. And if there is a delay beyond what was expected, you'll want to understand what payments can I expect during that time that there is a delay. Now, Kelly, I think you want to jump in because you have an additional point you want to make.
I do, Bill. Another question that a lot of folks have had and that you could consider talking to your solar developer about is, will you be paid rent during the decommissioning period? Is that decommissioning period going to be part of the operational stage, or is there a separate level of rent that you'll be paid? Because again, your land is possibly going to be tied up during that time frame. Another piece that you'll hear about if you read our fact sheet that we're going to share later is also thinking about if you have adjacent land that you own that you're taking any obligations on for. So perhaps an easement to not have trees or anything that's going to block the shade. Are you receiving anything for that land, which is also being restricted, even if it's not technically part of the acreage of this lease? So you really have to sort of get creative, think outside of the box of all of the ways that your land might be impacted and thinking about if you're going to get paid for it. And another key piece that we typically touch on is thinking about how are these rent payments going to change over the years? So $1,000 today is going to be worth a lot less than a lot more than $1,000 10 or 20 years from now. So you may want to think about an escalator or an inflation adjustment clause, typically just a percentage per year that steps up that base rate so that you're still getting paid even as inflation changes.
And the number we've typically been hearing is somewhere in 2 to 3%. Many of the agreements do not have that accelerator. You, as Kelly said, you want to have that accelerator in there. And 2 to 3 has been fairly typical for what we've seen so far. Also, you'll want to consider, that's the third main bullet, does your farm budget allow for variable versus assured monthly, yearly income stream? And depending on your answer to that may then determine what kind of payment option you want up at the top of that slide. You may just want to be paid a set amount per acre per year because you need that guaranteed income stream. But if you're willing to take a little bit of risk and have some economic value be created based on how much energy is actually generated from that solar array, then that may be something, variable payment that may be very comfortable to you. But think about that again up front. We've already talked about liability insurance, so let's go to the next slide. So signing bonus and attorney's fees. A number of solar developers are including a signing bonus in the agreement. If you sign this agreement, we will pay you $3,000. Now, there's usually, or oftentimes, there's a time limit to that. If the time limit is 30, 60, 90 days, I don't think we have as many concerns as if the solar developer is saying, if you sign this agreement in the next 3 days, I'll pay you $1,000. We strongly discourage you from ever signing an agreement if there's that short time period, because that doesn't give you enough time to seek competent legal counsel and is an indication of a high pressure sales tactic, one that I used to police a lot when I was at Consumer Protection. And so, yes, if a developer comes to you and says, hey, I'll give you a signing bonus if you sign in the next 3 days, that's probably a pretty good indication to walk away from that solar developer. And just beware. And secondly, they may offer to pay reasonable attorney's fees for you to go to an attorney. I think that's a great thing, so it doesn't act as a disincentive for you to not enter into that solar agreement because you can't afford to pay an attorney. Again, it's mostly tied to reasonable, but realize or recognize that the developer may ask you to see an attorney of their choice. No, you want to see an attorney of your choice. And one of the projects that the Farm Bureau is working on with UW-Madison Extension is to publish a list of attorneys who have experience in doing solar leases. We're not going to ever tell you to go to a specific attorney. We don't make referrals like that, but we've had a number of landowners say, can you at least tell us who's reviewed these types of agreements? And so we're working on publishing that list, hopefully by the end of the year or early next year. And it's great that we're able to partner with the Farm Bureau on that.
We did cover a number of issues in the last 45 minutes or so, but it's probably not quite as complete as our fact sheet that is available to you that will describe everything we did talk about today, as well as a few other items in more detail. We worked pretty extensively with Wisconsin Farm Bureau Federation and our other partners in the R-STEP grant process to put this together. This is an updated version from the one that was released last November. So if you've looked at that one, there's a little bit more information in here. We encourage you to check it out. In addition, we've also released a conversation guide. So we understand that sometimes it can be hard to take all of the information from the fact sheet and say, you know, what am I actually supposed to ask my solar developer or my attorney? How do I help my attorney help me? So this conversation guide is not necessarily all inclusive, but we've tried to cover some of the main questions and talking points that you're going to want to ask your solar developer to learn about both them, your offer, and the proposed project. One thing that I really like about this conversation guide is if you do choose to use it and fill it out, it can also sort of function as a term sheet of sorts. So for example, this is where you're going to try to record those oral promises that are being made to you from the solar developer. Once you're done with that and you've got a copy of the written lease, make a copy of your conversation guide, put it with your lease, and then take it to your attorney. Because what they're then going to be able to do is they're going to know from your conversation guide, what were those verbal promises that you were made? What are you expecting to see in this written lease? And they can actually confirm if those provisions are in the lease and are going to be enforceable or not. It's not something you have to use, but it's just a tool that we created to hopefully guide you. Like I mentioned, it's not all inclusive. So on the very last page of it is just a list of lines where you can add questions that you're hoping to ask them and can continue to add notes. Both of these documents or resources are available at the Energy on Wisconsin website, as well as the Farm Management Page website, and I think on the local government education website as well. Again, I will send out links to all of those after we finish the webinar today. If you are on your computer and are eager to get them right now, we did include a QR code to the Farm Management Page, so you can scan that with your phone with the Photos app, and it should pop up a little link that you can click on, and it will take you to the page where those are posted. So I will leave that up for a second.
And perhaps while that's up, we do have a question. If a developer offers me a contract that doesn't have important factors like the inflation and adjustment clause, what's the best way to go about getting them added? And that is why we're holding this seminar. The best thing to do is to go to your attorney. Again, hopefully it's an attorney who has experience in negotiating, and the attorney can negotiate that provision into the agreement. Typically, they're not going to change the written agreement, what I would almost call the more boilerplate language, but you can add an addendum or an appendix to it, which has the additional provisions that are included in that agreement. So that is the best way to go about negotiating. And you may have a developer who's saying, nope, I'm not interested in doing that. That may tell you then that you want to wait until another solar developer comes along that may offer you better terms for the land that you're going to lease.
As we jump into questions, I'm also just going to share this. Sherrie had mentioned earlier as well that the resources that we're putting together are supported by a grant from the U.S. Department of Energy. But of course, the items that we talk about do not necessarily represent the views of the U.S. Department of Energy or the United States government. But we're happy to continue to take questions. I will put up Bill and my contact information as well. So in the event that you don't want to ask a question here today, but want to follow up with us, you are able to do so. I will also mention, we mentioned that we are recording this session, but if you submit questions through the Q&A, those should not, or at least I will block out, they will not be in the recording, so they should be relatively anonymous.
All right, and feel free to contact either of us if you do have questions. Again, we can't be your attorney, but we can help give you some education and training, as we call it, at University of Wisconsin-Madison Division of Extension. And we're very, very willing to try to help out to help get you to better understand the terms of agreement that a solar developer may be asking you to enter into. And hopefully everyone found today's presentation very helpful. That's part of the reason why we're recording it and making sure it's available for other participants at a later date as well. So with that, any questions, Bradley, that you've been tracking?
Brad,
That we should answer?
looks like the only question that we haven't addressed was it deals with solar projects that may be on your barn or your tool shed, and sometimes those just don't pencil out. What are you seeing on that front when we talk about those would be more for the local individual farmer? What are you seeing on that side?
Yeah, that's a great question, Sherrie. I don't know if you want to answer that. Otherwise, I'm happy to jump in.
Sure. So there is funding available for farmers to offset the costs of putting solar on their barns. And the funding is both through the federal government and also through Focus on Energy. And I put in the chat a link to the USDA's REAP funding program. And the next application for that is actually September 30th. So if you're thinking of doing energy efficiency upgrades or solar, I really suggest going to the funding part of the Energy on Wisconsin website, where we've listed the REAP grant, and then you can get the links to the application, to actually our state representatives for USDA who will help you through that. And also there are links to Focus on Energy's rural program, which will also help with funding. But
Yeah,
I'm sorry. When
no,
you,
go ahead,
you
finish.
put solar on a barn, typically what happens is the energy goes to you first to offset the use of your operations. If there's anything left over, it then goes to the utility, and then based on your utility, depending on what your utility is, you get some remuneration. It's usually far less than what you have to pay per kilowatt hour of electricity, but that's typically how it works.
Yeah, and I'll just add on to that. So there's a agreed payment that the utility is willing to make. It's called a tariff rate that gets filed with the Public Service Commission. And I think part of the question was, how can we get that changed? There's a number of advocates that have talked to the Public Service Commission to try to get those tariff rates changed. But that's something that has to be handled by the Public Service Commission. And there are some utilities that will pay more than others, typically, but not always. The local electric co-ops tend to pay more for the energy that's generated. But again, that is subject to this public policy discussion that goes back and forth between the utility and the Public Service Commission. And so that if you're interested, you're going to have to go into that arena to try to argue for a greater payment.
All right, another question came through. I'll ask it kind of in two parts. One is, there is Kelly, I believe you talked a lot about this when we talk about the various aspects of the lease. There may be a construction, there may be a due diligence, and then there's actually the actual contract. What's the length that you see on those? And typically, or have seen, is there extension periods onto that production standpoint?
Yeah, there certainly are. So typically these contracts I shouldn't say these contracts, these stages are all typically contained in one primary contract. So you'll see development, construction, operations, and decommissioning all in that same initial contract. Again, thinking through the stages, development is typically about 3 years, construction 2, and then operations 15 to 20. With then typically automatic renewal provisions that if the solar developer would like to extend for another 5, 10, 15, check your individual contract to be sure what's being offered. But again, typically 5, 10, or 15-year extensions on those leases. I should also mention that when we think about the 3 years for development and 2 years for construction, those are, of course, subject to the solar developer's timeline. So if after a year or after 6 months, they decide we've done all the due diligence we need and we're moving forward, they may I should say typically in those contracts, have the right to proceed into the next stage just by giving you notice. So just because it's set up to be a 3-year due diligence and 2-year construction doesn't mean that it might not be shorter or quicker than that.
But
So
they
again, we're
also,
looking at 3 phases typically, with renewal periods for that, for the contract at the end. And then the length in the kind of, I guess, the expected life cycle of the panels. What are you guys here on that front? And that's more of an industry question. I don't know that that's a particular lease you've seen, but what have you guys read on life expectancy of those panels?
Typically, what we're hearing is about 15 years. So it kind of syncs up with that operations period that here in Wisconsin, those panels are going to last for about 15 years.
And I mentioned before, there's some degradation of the panels. Sherrie, looks like you want to offer something there too, but that is something to consider, that there is a degradation of the panels over a series of years. And so they lose the ability to produce the same amount of energy over time. And that's why, again, when you get to decommissioning, if the agreement allows you as the landowner to take over the operation of that solar array, and I know that there's a question related to that, it's going to generate less solar energy at that point, and so it may have a different economic value and different economic considerations at that point. Sherrie?
I just wanted to say that solar panels have the technology has improved. They're more efficient. A lot of our developers are using bifacial solar panels, which means that they can actually generate energy from the backside as well. Most of them that they put in, they will have follow the sun and tilt and move with the day. And then if there's snow underneath them, it reflects more, they generate more energy. That all to say that they have a longer life than 15 years. Of course, we haven't had 30 years to know where they're going to be at that point. We do know there's some degradation, but they are making them more efficient, and the technology keeps changing. So we don't expect them, if you sign a 30-year contract, to come in and change all the panels out at 15 years necessarily. So I don't want to have anybody have that misconception at this point.
Yeah, I will add, talk to your particular solar developer to be sure. This is where Sherrie and I come from different perspectives. So Sherrie is our energy specialist, coming from the legal side. I say 15 years because when I was in private practice negotiating, that was often what the solar companies that I worked were telling my clients. Was that, well, we don't want to fund decommissioning until we're 15 years in because we're not going to need to do it until 15 years and we'll replace them. So always, when in doubt, talk to your solar developer about what their expectations are for the technology that they're going to be using, and make sure that you're balancing those risks accordingly.
And actually, the federal government's very concerned about decommissioning and the costs, and part of the grant that we're working on will actually be helping to advance that and make it easier for landowners to have better agreements, and maybe just take it away and make the state get involved, or at least have the developers sign up front that they will take care of that. So we're hoping for those kinds of improvements.
But Sherrie, let me build on that just a second, and maybe it relates more to, I know Bill talked about this. There is the option, or Bill has maybe seen an example of this. I'm not implying this is widespread, but Bill has maybe seen a contract or two where the developer actually says, we're going to walk away after so many years, and you as the landowner actually get the panels, and then you can directly contract with an electric company to sell it, and you get all of the profits, again, turning the entire project over to the landowner. Again, I'm not implying that's widespread, but Bill, you've actually seen something like that?
Absolutely. Yeah, absolutely.
Okay.
Yeah, I've definitely seen it, and again, that could be a good deal if the solar developer is using state-of-art technology, as Sherrie is talking about. in high quality solar panels that aren't going to degrade at that 2%, because we really don't know what technology is going to look like 5 years from now, 10 years
That's
from
right.
now, and so on. This actually could be beneficial. I'm sure the solar developer has thought about, okay, what economic value are we giving up at that point, and negotiated a different payment schedule based off of that, because after all, they want to profit from the overall process. But this might be something that could be beneficial in the future. It's just right now we say be aware that there is a risk there. We're not saying it's a good or bad risk, just be aware of what it is. And you'll always want to mitigate that risk by having your lawyer negotiate provisions that will hopefully shed some of that risk onto the developer as opposed to you and get you the best possible deal.
Yeah, I would say that it is risky. It puts the risk on the landowner.
Well, I think we've covered all the questions that have either come through the chat or that have come through the Q&A option. And so, Bill, Kelly, Sherrie, I'll just give you guys a couple seconds to wrap up if there's anything the three of you would like to touch on.
Sherrie, do you want to start first?
Sure. I guess what I would like to put out there is that obviously you're a member of your community, and every community has a sense of place and strong feelings about where they live. And this is a big land use change, and it's a land use issue. And so I just want to put out there for everyone that we are working on this on many levels and how it affects the community as a whole and different stakeholders within the community. And please encourage your local governments and community members to look at our resources and to interact with us. We're going to be doing community conversations in other parts of the state, and we're going to be holding tours so people can actually go and visit different kinds of solar and wind facilities. So we hope you'll just stay in touch. I know you will, because Brad's going to get it out to you all as we have the opportunities.
Yeah, maybe I'll
Kelly?
go next, or Kelly, you can go next.
Either way, I can jump in as well. The big takeaway for me today is that we hope everyone recognizes that, again, we're neither for nor against solar, but just trying to help you have information that you can make the best decision for you, your land, your family, and your community. I did drop into the chat a link to more resources, which includes the fact sheet that we talked about, as well as the conversation guide. I do also plan on uploading this video there once we have made sure that it is ready to go. So you can find more resources there or at the Energy on Wisconsin page. I've also dropped in the chat a Qualtrics survey link. So again, because we received federal funding, we want to make sure that we're meeting your needs. If you can click on and fill out that evaluation for us, it helps us make sure that we are getting you the information that you need and that we're getting it to you in a clear way. So please do fill that out for us. We really appreciate it. And again, I will be sending out an email after the conclusion, which will include all of the links to our resources, the PDFs of the fact sheet and the conversation guide, and where you can find more resources. But really appreciate the chance to talk with you all today, and I will turn it over to Bill.
Yeah, and I'll just wrap up for the speakers by saying thank you very much for participating. This is the way to get well informed about agreements that you may be presented with. And if I'd learned nothing else from my 6 years as head of the State Consumer Protection Agency, we would get about 200,000 complaints and inquiries a year from consumers, is that there were very few complaints where the agreement was well written and where both parties understood what the terms of the deal would be. So if there was a disagreement, they knew how that disagreement was going to be handled. So all we're saying here is understand your agreement, make sure you've read it, make sure that if there are any oral representations that have been made that you think are important and need to be included, that your attorney makes sure they get included, because chances are then if is a chance of a breakdown in relationship, your agreement's going to define what happens in that case. And so you won't have that permanent breakdown that I have seen so many other times in contracting relations. So thank you very much for participating. Again, we hope this was a valuable use of an hour and a half of your time.
Yeah, well, I want to say thanks again to each of you, Bill, Kelly, and Sherrie. Thank you so much for the information you provided. It's so critical. I think that your presentations show the sense that there is a lot of questions surrounding this that you as a landowner need to consider as you move forward. And I think based on the number of slides you guys had, money is not always the most important things. There were so many more questions besides the money. While that does weigh into a decision, it is not number one. And I think the other takeaway is that we need to, each individual that's approached with these needs to strongly consider taking their agreement to an attorney and visiting with them to make sure they have legal representation on these contracts if they decide to sign one. And that should be prior to, obviously, before they sign one. So again, thanks everybody for joining us. We really appreciate this. You joining us. Thanks again, Bill, Kelly, and Sherrie. Great job again. And we be looking for more information as we keep moving forward on this. Thank you.